so that way you can hear us today. Looks like most of you are starting to connect in. Excellent. Welcome to another week of our Civics and Citizenship Professional Learning Series, brought to you by the Commissioner for Children and Young People's Office, the Department for Education and the Parliament of South Australia. I hope you're all feeling recharged after asking the Attorney General all your tough questions last week. As a reminder, if you could assist us by making sure that your name indicates who you are so we can track your attendance for issuing your certificates. Otherwise, Edgar might message you in the background. Now, before I kick off, I always love to recognise that I'm in Parliament House and therefore I'm on Kaurna land. Last week I was in Narungga country, but now I'm on Kaurna land. And I acknowledge the traditional owners of the land that I'm on here in Parliament House. When we talk about lawmaking, and we're going to be doing that today, I always think it's really important to acknowledge that the Kaurna people had systems of customary law and practices in place well before some of our systems were adopted and in place in South Australia. I would be really delighted if you would like to acknowledge country in the chat if you're coming from different parts of the state so we can see where you're on today. I'm really excited about this week's session because our guest speaker is Dr. Sarah Moulds, who is an absolutely wonderful academic and an even more wonderful person. So it's lovely to have Sarah joining us. Sarah Moulds is a senior lecturer in law at the University of South Australia and is really passionate about connecting people to legal systems and accessing all of the rights that they have available to them within our legal system. So whether that's parliamentary engagement or understanding justice systems, Sarah is really passionate about it and is the co-founder of the Rights Resource Network SA. And I'll drop a link to that in the chat as well so you can see some of the work that's happening in that space. Now, I was going to hand the floor over to Sarah because you're probably all sick of the sound of my voice after the last few weeks, but I'll be in the chat and please feel free to use this opportunity to ask questions and make sure that you understand cases, common law, and change. So thank you so much for joining us, Sarah.
Thank you so much, Nat, for having me, and thank you, Emma, and the Commission as well for being part of this great session. And it's such a joy and a privilege for me to be talking to all of you great teachers because I deeply admire the work that you do with your students. And sometimes I'm lucky enough to see the fruits of your labour when beautiful young people come to study first-year law with me. And I can see the impact and influence that their fantastic high school and primary school civics and history, humanities and social studies teachers have had when I see students with the confidence to be able to articulate their own ideas and vision for change in the world, and who have got strategies for testing their ideas and providing evidence to support their ideas. So please know that the work that you do follows through into these wonderful, active, bright young scholars that we get the privilege to engage with at university. I also want to acknowledge that I'm possibly speaking to a room of experts definitely in education and pedagogy that I'm keen to learn from because I don't have teaching qualifications. I've got law qualifications and teaching experience, but I have a deficit there that I'd love to learn from you from. But also that some of you might have quite advanced expertise when it comes to engaging with law and legal sources. So I wonder if you can indulge me by just having a little look at this poll that should come through to you. It's not compulsory, but if you'd like to complete this poll, it would really help me get a sense of your own experience when it comes to case law and courts, so that I can pitch my presentation in a way that makes the most sense to you. Also, I'm very used to people lobbing in with a question, putting things in the chat. Unfortunately, I'm also used to people multitasking by looking at their phone or possibly even serving at the checkout while they're attending one of my Zoom tutorials. So nothing you can do will surprise me. But if you've got a question or a comment, please just go for it. I really want to make this useful for you. The other thing is the slides and the resources that I mentioned can be shared with you afterwards. And at the end, I'll share my contact details because let's stay in touch and I'll work out ways that I can support your great teaching in the classroom. Okay, There's a couple of people who haven't had a chance to answer. I'll just give it another second. And meanwhile, I will try and share my screen. This just takes a moment to get looking right. How's that looking, Nat? Is that looking normal?
Looks good. I can see it very clearly. Thank you.
Okay. I'll just give one more minute for the poll, and then I'll share the results with you. But it looks like there's quite a few of you that are really excited to learn about this space because your experience in dealing with cases has been, you're at the beginning of your learning journey with that, which is great. And there are others of you that have got some general knowledge about the court system, but maybe less experience reading cases. So that's really fantastic. I'm just going to end the poll and share the results so you can see here. So that's great. That gives me a good sense of how I'm going to pace this presentation today. Okay. Get rid of that poll. Sec. Okay, so today I think we need to start at the beginning of our conversation about, what is law anyway, and how do the courts and cases fit into that concept of law. Before I hopefully give you a little bit of technical information about court hierarchies and jurisdictions, a few tips about how to find and read cases, and also hopefully some tips about how to use cases or how your students might want to use cases to support inquiry type projects and to develop arguments. But I guess my take home message is, as teachers and in fact as active citizens, have a go with the law. It's not a mystical thing that's really difficult to understand. It's part of our everyday life. And our concepts of fairness and justice and equality, the idea of treating someone with dignity and respect that you model every day in your classroom, that is the same ideal that underpins our legal system. This idea of balancing out power between institutions is something we live and breathe every day in the school setting. And our young people should feel encouraged to dip their toe in, to have a crack at looking at something, even if they don't fully understand it, and to imagine a world where they get to change the law, no matter whether they know a lawyer or a politician, whether they've read any cases or not. So I think that's my takeaway message. In the same way that I might read a poem or look at a piece of art without the training to appreciate the finer details, I can still get something out of that picture or that poem. I want to say the same to you when it comes to law, to have a go at looking at the law in that way. So before we get started on the technical details, I think when we talk about law or teach law or try and understand it ourselves, we need to think about what assumptions we give this concept of law and how it fits into our life. So for me, when I teach law to first years, it's really about this concept of power and identity and our relationship between the state and other individuals living in the state. So the things that make me human include my right to dignity and freedom. The things that make me part of a state is that I can identify which institutions have control over my behaviour. And the things that make me free is that I get to participate in a democracy. And that's really how law fits in. And they're the different angles we can come at law from. So we can look at it from institutional power and roles in developing law. We can look at it from the idea of freedom and dignity and rights and helping each other in the community. And we can look at it from a rules-based system. But to me, the rules-based system is the least interesting. The other things are the most interesting. And it's those other pathways that I think are the easiest ones to walk down when you're trying to encourage students and your own peers and colleagues to enter this land of law. When we think about law as norms around behaviour, and this idea of vision for our community, we see that they're very similar to the type of environments we're trying to create in a classroom. And if our classroom environments model these concepts of democracy, of procedural fairness, of respect for authority, but also empowerment of the subjects of that authority, we have a lot of entry points into the judicial system, the parliamentary system, and the executive. And I know the Commission and the work that Nat's doing are about empowering people to think about their classrooms as little mini democracies. And if you think about your role as the teacher as sometimes being like that judicial figure, it can be a great entry point, I think, into some of this stuff. It's also important to appreciate that, as we know, law is influenced by these other concepts, including ethics and politics. And this can be powerful for students who are approaching legal studies or other inquiry-based topics, to really think about how they're going to use law to add authority and substance to arguments they're making around politics and ethics, and sometimes to draw out the tensions that might exist between those other spheres. So it becomes less about using a case as some kind of perfect enunciation of a rule that must be followed, and more about using the case as an example to draw out a bigger picture idea or tension that might fit within concepts of ethics and politics. And when I look at the curriculum, I see evidence of that in terms of what people are looking for at that year 11 and 12 level. And going down into the earlier years of high school, I think these concepts dominate the curriculum in that area too. So I see these concepts as freeing us up when it comes to understanding the courts and the cases. It's okay if we don't have all the technical details right, because we're leaning into these other spheres. So I think we know the things on this slide here. If we understand law as coming from both the courts as well as the parliament in our democracy, we can see that the law can and does and always will change. And that's because we live in a democracy where we get to decide what the parliament does in terms of lawmaking. And that should empower us to think about how to change the law. And it should also give us reason to pause and think about this idea of parliamentary sovereignty, which you've probably come across before, which I won't talk about a lot today, but it's important because it says at the end of the day, if the courts are making a decision about the law for the future, the parliament gets the final say on what that looks like. In our democracy, the parliament gets the final say, and we'll talk through some examples about that later. But what it means is if your students are thinking about the role of judges in the system, it is important, I think, to remind them that regardless of where that judge is in that court hierarchy, it's the people through the parliament that get the final say in our legal system, in our constitutional system. And to me, this is an empowering message, particularly if we're looking to think about how the law might change. The other thing that you guys would be really well aware of are these characteristics of the legal system. And I put this up here because I think today we're going to talk a lot about the common law system, but these other features of our legal system are really important and keep butting up against that judge-made law, common law system all the time. And the other balls there that you see on this slide really guard against the misuse of power by any particular institution, by either the parliament, the executive, or the courts. And they're designed to kind of get this balance right when it comes to power in the system. So if you're looking critically at the role of the courts or the role of judges, I think it's really important to think about these other balls on the screen and what role they play in either exposing any criticisms of the judiciary, but also mitigating against those criticisms. And so that might be a relevant factor to consider if students are thinking about, you know, who are the judges? Are they investing their judicial decision-making with personal attributes and qualities that they have as individuals? And if so, how do these other features of the system operate to guard against that misuse of power? Separation of powers, I'm sure you're all over this, but again, I think it's just useful to hold this in our brain as we start to get into the detail of judge-made law. And that's because this is one of these concepts that looks so beautiful on the slide, these beautiful clear boxes here that make us feel happy when we're teaching it, and students love something like this that's very clear. This is what people imagine law to be like, boring, straight and clear. But actually each one of these boxes merges in a messy gloop with the other. And to me, this is super exciting, right? We want to make sure they don't completely become one super blodge, because then we're kind of Myanmar. I went to Myanmar 2019 to talk to their parliament, and, you know, they've got a big blob. But in our system, it's also, I think, important to understand that we want to convey the ideal of our founding fathers in our constitution, which was beautiful, clear boxes here. Legislature, parliament makes the law, that's democracy. Executive, public servants, police, ministers, crown, they administer the law, they prosecute, they investigate, they make decisions about our housing or our social security. And then the judiciary is like the umpire. Is everyone else staying in their box? What's the outcome if there's a dispute? What does the law mean? Beautiful and clear promise designed to make sure no one box is exercising too much power against the individual, to preserve that individual freedom and dignity. But the executive includes the government, and the parliamentarians that make up the government are also in the legislature because they're in the parliament. And those executive gang, they get to make the law lots, as we know from COVID. They're always making the law. And then what about the judiciary? Aren't they making the law too, particularly when it comes to common law, developing the law as they resolve disputes between individuals? So there is really interesting interactions between these boxes. But I think thinking about our legal system as being designed to separate, diffuse power is a powerful message. And it's also a powerful message around change, because it reminds us if we can't change one thing, maybe we go to a different box to try and affect change. And a great story for this is a group of young people who worked with a nun to challenge a decision around coal mining and whether or not a development should go ahead to mine a certain natural environment area. Now, those young people couldn't vote. They couldn't vote in an election to vote in a legislature that put climate first and didn't want to see coal mining. They didn't have that capacity because they weren't old enough. They tried making representations to the government, writing letters and sharing their thoughts. That didn't work either. And actually, it was the minister who was making the decision about whether or not the mining should go ahead. So these group of young people, with the help of a nun, because they needed an adult that was able to take a matter to court, went to court and said, when the minister is applying this law that the parliament made about environmental protection and land use, that minister should think about us, the young people, the future generations, as they make that decision. And the court said, hang on, those words aren't in the law that the parliament made, but let's think about this for a minute. Let's listen to what these young people are saying. Is this something important for our democracy to think about? And the court at the first instance agreed with those young people and said, Minister, at the end of the day, you've got the legal power to make the final call about whether there's a coal mine. But as you make that decision, you have to think about the impact on young people. That's what the court at first instance decided, right? Then there was an appeal up through the court hierarchy that we'll get to. And that decision was overturned on appeal. And then we see the executive and the parliament responding to that litigation in the future by changing the actual legislation. So this is a story of how, you can agitate for change at different levels of this legal system, but also about the blurred experience between the two. Oh, that's my lights turning off. Okay, this is a good chance for me to double check the chat in case I've got any questions. Okay, good one. Right, so that's the big picture. Now I'm going to get into a little bit more level of technical detail here, talking about one of those balls, which is our common law legal system. Now, common law legal system is a bit of a mind-bending idea because unfortunately these words common law mean all sorts of different things. So when I was studying in Germany, everyone said, oh, you come from a common law system. And what they meant was a system that's different to the continental, system that exists in Europe. In Europe, they have inquisitorial approach to court cases, and they have a really different way of thinking about judges. Judges are really much more like public servants, much more like the person that might sit on the other side of the Centrelink counter, receive all your documents and make a decision about whether you're eligible for the childcare rebate or the social security payment. They kind of administer the law in a very literal sense. And if there's a criminal matter, those European judges, they investigate the situation. They work out who they're going to call for witnesses. They collect all the documents and make a decision. They don't see their role as developing the law into new areas. Whereas in our common law system that comes from our British heritage, we do see a role for the courts in developing the law in response to different cases. And that's how we get this idea of common law. The common law words, those words, can also have a historical meaning, which distinguishes them from courts of equity. And this goes right back to kind of Monty Python, Holy Grail era, where you've got barons making the decision, land barons, about what happens in any certain circumstances. Should you be able to plant your crops here? Should this person have given you 3 chooks instead of 7 for the sheep? And the land baron would make the decision about that dispute. That was common law for the common people. That brings to mind the particular phrase in that Monty Python skit, which I won't say because it's got rude words in it. And then at the other end was courts of equity. That was when the king was involved. That was when you had a gripe against the crown. And that might be because, for example, you're detained for no reason, or the king has tried to compulsorily acquire something of yours. And that was the court of equity. So eventually, cut complicated story down, there was a merging of those two different courts and the type of remedies that people could get from those courts. And now we lump it all together in this idea of case law or common law. And then the final way of thinking about common law is distinguishing common law or cases, judge-made law, from legislation. And really, I think it's this last one that you guys are dealing with. So you're saying to your students, give me some sources of law in your inquiry project. Or you're saying to your year 7s and year 8s, what does the law look like? And you're wanting them to say, well, it looks like something the Parliament does, which is like an act, or it looks like a decision that the judge makes, which is a case. And that's how we get this common law idea. Then, just to kind of make our brains explode a bit more, of course, we don't just have the idea of common law and legislation. We also have other ways of organising different areas of law. So we have ideas of criminal law and civil law. And they bring with them a whole language, right? And you've experienced this in your own teaching, these whole discourses that come with different pedagogies. And, it can make things confusing. But again, I just say, don't worry too much about it. Who cares? if we're saying remedies instead of penalties. You know, I don't think that matters at all if we're encouraging our students or our colleagues to interact with these materials, but sometimes it helps us to think about how the language works when we're dealing with different areas of law. And it might also impact which courts we're going to if we're looking for cases or if we're imagining different disputes. So that brings me to this idea of the court hierarchy. Now, this is another picture that the students really like because it's all clear with nice clear boxes. This idea that we've got a triangle of courts with the High Court at the top. And I think the way to understand this hierarchy is really to focus at the very pointy top part with the High Court and then at the bottom, and not worry too much about the middle part, to be honest. The top part is very important because the High Court of Australia is in our Constitution. And it's connected so much to our identity as a nation because, in fact, it was the 1980s, up until the 1980s, the court that was at the top of this hierarchy. Does anybody know what court was at the top in the 1980s, 1986? I feel like I needed chocolate to give to anyone who could have a guess. Anyone know? It wasn't the High Court. It was a different court right at the top.
Sarah, I'm struggling to hold back from giving the answer, but I think someone in the chat just got it.
Yes, exactly. So we had English courts at the top of our hierarchy until 1986 because of our colonial history, because of the fact that our constitution still imagined ourselves as having this strong alignment and allegiance with the British Crown. In fact, there's no concept of Australian citizenship in our constitution. We're all assumed to be British subjects, cause a whole lot of problems. But now we've made the decision after the Australia Acts that the High Court will have the final say. And this is so important because they get the final say about our constitution. So if we go back to that slide, imagine going back to that slide with the separation of powers, are we making sure Parliament executive stay within their boundaries? That's the High Court's job. Also in our constitution is a fundamental right that says any individual that's wronged by an organ of the state, someone exercising power on behalf of the state, they must be allowed to knock on the door of the High Court and say, what you did was unlawful to me. And this is a powerful rights protecting feature. In fact, we know, don't we, that we don't have a constitutional Bill of Rights in Australia. But this thing connected to the High Court, this jurisdiction of the High Court that says every individual that's wronged by an executive officer of the state can go and say what you did was unlawful is a very powerful safeguard that can't be taken away. So that's the High Court of Australia. Also, the High Court demonstrates what judicial power looks like to everybody else. And they have the final say when it comes to appealing different decisions lower down the hierarchy. Then at the bottom, we've got the Magi's Court. The Magi's Court is where, well, first of all, we'll come to another slide. Most people never get to court. That's really for two reasons. One is because the prospect of taking a dispute through the court system has a number of prohibitive indicators early on for parties, including mental capacity and impact on relationships as well as costs, but also because most of the decisions that impact us in life are sorted out in tribunals, and I'll come up with a slide for that. But sometimes if we are going to court, we're very most likely to be in the Magi's Court, the Magistrates' Court, because they deal with the lower level civil claims, neighbourhood disputes, and the lower level criminal penalties. And so they have relaxed procedure, don't need lawyers. The thing about the Magi's Court is most of the action happens there, but not many of the cases come from there. And that's because magistrates are sorting stuff out like a boss with their oral words. And they're not writing out long judgments because, to be honest, I've seen this a gazillion times before. So they are doing that job that's a bit more like that European judge. They're just administering the law. So it's important for you and your students to keep that in mind. Most people, if they do go to court, experience court from a Madgy's end that doesn't end up with a 300-page long judgment with statements of law developing in new areas. The High Court does that. And so if you're unhappy with your decision in the Magistrates Court about your neighbour's fence and you think there's been an error of law, then you can take it up the line to the next level in the court hierarchy in South Australia. That would be the District Court. And if you're unhappy with what the District Court has said, and you can point to an error in law, a problem in the way that the judges implemented the law, you can take that up the line to the Supreme Court, and then you will need to go to the High Court. If your crime is serious enough or your claim is expensive enough, you enter straight in at that District Court and Supreme Court level. So the seriousness of the offence, the size of the claim can impact which court you start in. And if you're unhappy and you think a mistake's been made, you move up this hierarchy in that way. If you have a problem with something that the state's done against you, you have this fundamental right to go to the High Court. But because they appreciate that the High Court would get rather busy with that kind of door knocking, they have the federal court system, which means you can go through the federal courts to hear claims against federal public servants. And you see on that hierarchy there, we've got the family court. The family court, again, is very busy, but most of the things that the family court are doing, which won't surprise you, is they're kind of stamping stuff. And that's because most family law disputes are where good people are trying to work out what happens next after a relationship breakdown, and they're coming up with a plan themselves, and they need the court to stamp that out. Sometimes there's complexities, particularly to do with children and property. Even so, it's rare for there to be a full judgment delivered in the way that we might imagine common law to look like, although it does happen sometimes. So most of the juicy cases that we're wanting to use to say, look, this is what the law is, or look, this is how the law has changed, are likely to happen in the High Court, the full court of the Federal Court, or the Supreme Court in South Australia. That's where we're likely to get those judgments from. So even though the action's happening in Magistrates Court, the good cases are coming from higher up in that hierarchy. Okay, so the Youth Court and the Nunga courts, yeah, thank you so much. So each of these courts are governed by a piece of legislation of their own. So the Magistrates Court Act, the Supreme Court Act, the District Court Act, the Youth Court Act. And that sets out their powers and functions. And it also sets out where you go if you think a mistake has been made in that court. And so the Youth Court pretty much fits somewhere alongside the District Court here. So you appeal straight to the Supreme Court most of the time from the Youth Court, but your ability to go to the Youth Court is governed by that Youth Court Act. Yeah, so I think, and your question here is around this idea of your right to go to the High Court. Yes, that's true. Not many people would consider this to be an effective way to sort the problem out. And that in a minute, we'll see why they established the tribunal system for that. But it is still a powerful safeguard in our system. Yeah, and it's been used really powerfully sometimes to change the course of the law. Here's a more complicated slide with all of these different bits and bobs in it. I'm going to skip over it, except to say that, you know, this big facts law arrow really demonstrates that as you move up the hierarchy, the focus is on, has the judge below interpreted the law properly? As you're down the bottom, it's likely to be questions of what are the facts in this dispute and how do we collect that evidence in a sensible way? So the witnesses involved in giving evidence, the documents and materials, that all happens at the Magi's Court end, but the interpretation of the legislation, that debate is likely to happen higher up in the court hierarchy, which is why we see those written judgments more frequently higher up in that court hierarchy. You've heard me say this word jurisdiction, and jurisdiction, you know, is one of those words that can be off-putting to people, but it basically means two things. Where are you on the map, and what power do you have to make a decision about me? Now, most of us are pretty good at the where are you on the map, right? So if you're in South Australia, surprise, surprise, you're going to the South Australian Supreme Court. But the one about what power do you have to make decisions about me does require a little bit more investigation. And often that can be around the difference between state and federal courts. So if you're the SA Housing Commission, you get your power from the South Australian piece of legislation. The decisions about you that are made under that Act are going to be sorted out in the South Australian Supreme Court or in one of the district or magistrates courts. But if you're Centrelink, that's a federal agency, so your disputes about Centrelink are going to happen at the federal level. And this will be sorted out by the legislation that sets up the court in the first place. There can be really complex questions around jurisdiction and overlapping laws, and that might come up when you're teaching areas of legal studies around inconsistency and coexistence of state and federal laws. And really it comes back to the story of our legal system. And I think if students have that story clear in their mind, they find things like jurisdiction a bit easier to understand. And that story is the fact that we had colonies first. The time of colonisation, we had the colony of South Australia, colonies with their own everything first, their own police, their own courts, their own parliament, their own constitution, their own way of keeping the convicts under control, of, you know, delivering land to the free settlers and sorting out their community and their society. And what happened in 1901 is those colonies gave some of that power up to the new Commonwealth, the new Federation, but they kept everything else. And so usually you're dealing with state power under state legislation, state court system. If you're looking at the federal court system, because you're thinking it's a federal agency or a federal area of law, then that will be one of the things specifically listed as being within the power of the federal parliament and the federal court system. And if you're not sure about that, there's two places to go. One is Section 51 of the Constitution, but the other is these bits of legislation that set up the courts. Okay. The other way of thinking about jurisdiction is this question of, is the court exercising original power, or are they checking that another court has got it right or wrong? And so if we imagine this fence dispute, so imagine my neighbour's built a fence that I don't like. I think they've broken the law. I go to the magistrate's court without a lawyer. I take my map and my documents and my witnesses, and I present it to the magistrate. So does my neighbour. The magistrate makes a decision about who's right and what should happen to the fence. That's the magistrate exercising original jurisdiction, sorting out the dispute at the first instance. But if I'm not happy with that, and I think, actually, I reckon the magistrate failed to consider something really important here, or was biased because, you know, their brother is the best friend of my neighbour, then I can appeal up to the district court and say, this magistrate got things wrong. The district court is then exercising appellate jurisdiction because they're checking to see, did the magistrate get something wrong? Now, for most people's purposes, in teaching this to students or asking students to engage in it, it's just about thinking the higher up the court is in the hierarchy, the more powerful and persuasive and authoritative the judgment will be. And so if students are looking for examples from judge-made law that have impacted our society, the higher up you go, the better. So that's the first thing. If you're looking for statements of law and judgments to engage with, go high. If we're thinking about systems of fairness that impact everyday people's experiences of justice, what does justice look and feel like and sound like? Then I think those lower courts are the place to be. The magistrates' court or the district court, where the witnesses are, where the people that have had the problem in the first place are sitting there, experiencing all of that emotion, looking at the person in the wig and saying, is that person like me or not? Can they relate to my circumstances? Those kind of questions of process and fairness, experiences of justice, lower down. The statements of law, higher up. So I've got in these slides the detail about the South Australian courts, just in case this helps you, but I'm not going to go through it now, I don't think. And I've talked about that. I'll just check my time here now. Oh, yes, better move it along. So I've talked a little bit about the adversarial system. I think most teachers are brilliant at talking about this. You know, the idea that this is the promise again, a promise that looks wonderful, but doesn't necessarily work out so neatly, which is the truth will emerge between these contests of two different ideas. And the judge sits there passive and quiet and waits for this truth to emerge. That's the promise of the adversarial system. In reality, we know what some of the weaknesses are, and they come back to power, don't they? And they come back to the ability of an individual to feel like they're being respected with dignity in that forum and able to bring forward the material to help the judge. The passive role of the judge is also something that has and does continue to change. And we see that in the magistrates' court where people are unrepresented and the magistrate is very active. But the higher up we go, so the high court proceedings will be the best way to exemplify that passive judge role. The lower you go, particularly the specialist courts, people have mentioned the Nunga court and the youth court, the less adversarial and the more opportunity for people to consider holistically what resolving a dispute looks like and to think more creatively about what justice is. And we've got that flexibility in our system. We can change that by legislation, and individual judges can change that as well by the way that they conduct themselves in court. But there are structural pieces in place that are designed to safeguard procedural fairness. And that is connected to this concept that you have a right to understand the case against you and to be able to respond to that case. And that's the idea of procedural fairness that sits behind this adversarial system. What about this concept of tribunals? I just mentioned this quickly because most people, if they've got a legal issue, are going actually to a tribunal because tribunals sort out anything to do with government before you need to go to court. And the good thing about a tribunal is they're not passive judges that sit there and wait for the different bits of evidence. They can stand in the shoes of the original decision maker and substitute that decision. So if a planning decision's made about you, if a rental decision's made about you, if a dog and cat management decision's made about you, you can go to a tribunal and the tribunal member can listen to your situation. You don't need a lawyer. You don't even really have to be bound by the same rules of evidence and procedure. And that tribunal member can come up with a different decision that's fairer and better in the circumstances. Really different to a court. At the end of the day, you can keep appealing so you get into a court system, but the tribunal space is an example of people saying the court system is not delivering justice for everyday people. Let's have another crack at government accountability through tribunals. So if you've got students interested in process and fairness and the idea of procedure and being able to present a whole picture to people and government accountability, tribunals are where it's at. The problem is tribunals don't make very big judgments either. They don't write out nice judgments. So we're less likely to see that example of common law come through from the tribunal system. So now I'm getting into the part quickly, where we're talking about how to handle this stuff called case law in your classrooms and with your students. So this has a little bit of where to find it and then how to read it. When a court makes a decision, and I've worked in the Supreme Court, and they're writing it out, printing it out, handing it out, and then they send it out far and wide by putting it on their website. And then once it's on their website, it's available through various means, including Ostly, which I'm sure many of you know is a fantastic website to find cases really quickly. The problem is that everything goes up there. So it's hard for us to tell which are the really great bits of case law that our students might be interested in that are going to set out the law and show change in the law, and what's the run-of-the-mill stuff where, you know, the magistrate's saying, I've seen this 1,000 times before. There's a few ways we can work that out. One way is these little letters after the year give you an indication of the court. So HCA means High Court of Australia. So if you're searching on Ostly for something like fence disputes and you see something with HCA, I'd be surprised, but you might, you know that's the High Court considering that. If you put in something like duty of care for the idea of negligence and claims around people being hurt, if you see something come up with HCA, you know you're onto a winner. If you see something that says SASM, then you might be looking at a magistrate's court. If it says SADC, then it's going to be district court. The other way you can tell whether a piece of case law is something worth reading is if it made its way into a book. Now, I know that our students don't really understand books. Definitely something that I experience on a daily basis, but the courts still understand books. And if you're before the court trying to argue your case and you say to the judge, this decision is a lot like another decision that was made by a higher court and it's in a book, the judge is very impressed, because the cases that make it into a book are the ones that have been used the most. How do you know if it's made into a book? Well, obviously you can find the book, but that's never going to happen. Instead, we're finding things online, but we can see these types of letters here that are about a book. And there's ways that we can share with you to find out what those different letters mean. But if it's made it into a book, you know it's a great one. And all of this information is available through things called case citators, which I would really not recommend as being that helpful, except for perhaps when students are at the Year 11 and 12 end of legal studies, in which case I'd suggest using the Ostly version of the case citer called LawCite. And if you're interested in that, I would absolutely be pleased to do a special session for you and or your class about how to use that material. And it will give you some great information to track how a case has been developed. And there's some of the case citators there. Another free tool that's fantastic in addition to Ostly is this thing called Jade. And the reason Jade is good is because Ostly will help you find a decision of the High Court. And then you click on that decision and you're like, oh, holy mother of whatever. Now I've got 300 pages to read. And all I'm really trying to do is get to the money bit, the bit where the judge is saying, here's what the law is now, and here's where I'm taking the law. Well, Jade helps you a lot with that because it has these little green arrows that point to the parts of the case that have been used a lot. And so you can literally scroll down till you hit a green arrow and go, oh yeah, this is the bit of the law that other people have used lots and lots that I'm going to use in my assignment or in my lesson. So it's a great free resource to use. And again, I'd happily do a session on Jade for anyone who's interested. When it comes to reading cases, and let's be honest, everyone's in the learning pit. So before we give a case to students or we look at a case ourselves, I think we have to be honest about why we're reading it and what it feels like to read a law case. It's not writing that's designed to kind of bring the reader on a journey of discovery and comfort. It is a technical analysis of arguments presented by individuals in court and the interpretation of decisions that other courts have made. So it's not so friendly. Sometimes it's more friendly than others, and sometimes it's more storytelling than others. And Lord Denning was a famous judge who was quite good at storytelling, and Justice Brennan, I think, is another example of that. So what I'd say is, first of all, ask yourself this question: do I really need to read this case? Does my student really need to read it? Or is there another excellent quality secondary source that summarizes it from a textbook or a journal article or a government report that gives the student everything they need to understand the case, and then maybe they can use something like Jade or Ostley to take them to the paragraph they need? Because it is a learning experience to read the case. And some of the things that we're looking for when we read the case are on this screen. I just want to draw your attention to the catchwords. The catchwords are the categories of the case, and this can be really, really handy when you're at the explore stage and working out whether or not you need this case and how you're going to use it. So these are the words that will say things like negligence, duty of care, or they'll say something like criminal law, sexual assault, so that you know what the case is about. And so I'd say that students at the beginning of this journey should look at those words and think, does this fit in? The other words are around jurisdiction. Is this in the right place on the map and with the right power? And the other thing that you're then looking for is, you know, what happened at the end of the case? What was the order and the outcome? And that's at the beginning as well as the end. The hard part of reading the case, so this is stuff that we can get pretty quickly, but to me, it doesn't really give us the power that we need to say this case stands for this principle. It's great if we're trying to find, you know, an example of where the magistrates' courts looked at fences or the Supreme Court's dealt with sexual assault, and we can say, yes, this is an example. But if we really want to know what the judge decided and how they developed the law, we need to start doing a legal analysis. And this is where I'd suggest, can you borrow a legal analysis from somebody else? If you're doing it yourself, this is the way we teach our students at university. Issue, rule, application of rule to facts and conclusion, or the IRAC model. So this is where we're saying to students, what was the legal question? So if we think about a case we might be familiar with, like Mabo, the legal question is this idea of what was the state of the landmass of Australia at the time of colonisation? The question was, does the doctrine of terra nullius, empty land, remain a valid legal concept in Australia? That was the type of big legal question considered in that case. Then we see the courts applying rules. So in Mabo, that was rules around property law, rules coming from other cases, but also rules coming from legislation. Then we see the court applying that rule around property law to the facts, which in Mabo were about that continuous connection of Torres Strait Islander people to a certain land area. How does that fit with the rule around property law? And then the conclusion, what was the outcome in that case? And in Mabo number 2, the outcome was terra nullius was factually suspect. There was something called native title that could coexist with property law in Australia on these facts. So this is challenging, and I would suggest wherever possible to borrow this legal analysis and perhaps critically reflect on it. But if you're wanting to do it yourself, then that technique can be powerful. And I'm going to flick through these slides, but this Rogers and Whittaker example is something that I use with my students at the very beginning of first year law that I could run as a module for you or your students around case analysis. And this is about the responsibility of doctors to warn patients about the potential risks associated with their treatment. So it's a good one to kind of explain how this case analysis might work. What about, though, the more common situation, which is how are students going to use cases in some kind of inquiry project? And this is where I think there's three ways that I see a role for cases. One is context and background. And this is really where the student is saying, this area of law has changed a lot in the last couple of decades and heaps of courts have commented on it. Then you're just putting a list, easy to find in Ostley. Great opportunity for them to practice finding stuff and whacking it in a footnote. They don't have to read the cases. Sometimes you're using it for legal authority. This to me is that higher level analysis that really is definitely important at law school, maybe year 12, but probably not for the others, where you're saying this judgment set out this legal rule. You have to have a lot of confidence about that. I'd say lean into secondary sources, again, less likely to be relevant to most subject areas, or if it is, someone's already done the work for you. The area that I think is really exciting for students is using cases as evidence to support one of their arguments or ideas. And so this is where, you know, I've got some examples of context and background, but this is, you know, an example from one of our first year uni topics where we're saying something like, the concept of what it means to be Australian is changing because can you believe there was a case where Aboriginal people were going to be deported on the grounds that they weren't Australian citizens? Isn't this an amazing thing that shows how concepts of what it means to be Australian are really fluid and dynamic and influenced by colonial history in Australia? In this situation, the student does have to have a general understanding of the case that they could get from a secondary source and those catchwords. They have to understand a little bit about what the case is about from its facts, but they're using it to support a bigger picture idea. And this is where I think any teacher, regardless of their confidence reading cases, can take an interest in the broader public commentary about what the courts are doing and encourage their students to think about, can you use a case to support their own idea? And some things that I don't think are that great. But you can follow them up too. I'm running a bit out of time and I've got some ideas about precedent here, but I think we have covered that idea of precedent from the court hierarchy. But feel free to have a look at these slides when we're not so rushed for time. I just wanted to, I guess, end with this slide probably, which is when we're thinking about how does the law change, it really changes because a dialogue of those different institutions takes place, a conversation between the courts and the parliament that's prompted by some deep injustice that's experienced at a very human level. And so if we think about these three examples here, the births, deaths and marriages versus Norrie, this was a case of a person who didn't identify as male or female saying to the births, deaths and marriages, I don't want to have my sex indicator on my birth certificate. And that led to the court having to work out, well, what was the rule here? What did the law say? What have courts said in the past and what did the legislation say? And the court said, well, here is a person who genuinely doesn't identify as male and female. We think it's a fact. And so therefore, the law has to give some way to this person. They should be allowed to have no indicator. Now, that was a dispute just around Norrie, just around one person. It was not saying everybody gets to come on down and decide not to tick a box. But because of that dispute, we see the parliament respond and create a process for people to tick a box that says not male or female. When we come to Mabo number 2 and the terra nullius idea, again, we have a question about a specific set of facts of Torres Strait Islander people, giving rise to this question about the validity of terra nullius idea, finding native title, but no process for what this means for everybody else in the community. So the Parliament has to respond by setting up an idea of how this is going to work. How are people going to be able to exercise native title? How do we balance that with other people's rights? And in Brown and Dunn, we see a different procedural example where we have concepts of fairness being sorted out in the context of evidence, very detailed questions about what type of questions should be put to witnesses. But it suggests a broader concept of fairness that we then see the Parliament step in to codify in the Evidence Act. So this discussion between Parliament and courts is how change happens. And I think from a big picture idea, it's an easy way in for students and teachers. So I'll just leave these details up here. I'm sorry that I got banging on early on and had to rush through the precedent part. But if you're able to stick around for a couple more minutes for questions, I'm definitely available. And I just want to reiterate again, I'm so hungry to get to know you and your students, and I'd be thrilled to run specific sessions for you and your colleagues or your students where we can take a slice of this and go into more detail. Thank you so much.
Thank you so much, Sarah. Sorry, I was just checking to make sure I turned my microphone back on. There are a few people giving you lots of thank yous in the chat that you could probably see coming through, but I haven't spotted any further questions. Is there anyone still online that had a question that they didn't get to ask, or yeah, you're welcome to pop on your mic and speak over the top of me if you like.
Maybe I can just quickly show you something on OSLI then that might prompt some questions. So often if a student's looking at something like, you know, what role does the judge play in sentencing offenders? You can use OSLI to think about, okay, we're in South Australia, so how about we chuck in sentencing, and you'll get the Sentencing Act, which is a piece of law from the Parliament, right, that sets out what the judges should do. And it's quite a great piece of legislation. It's got the general principles that the Parliament thinks the judges should think about when they're sentencing someone. And then what we can do really easily with OSLI is press this little button that says Note Up References. And if we do that, we get all the cases that have considered that particular part of the law. So a student very quickly, in a matter of 2 or 3 minutes, gets 2 primary sources. The part of the legislation that guides the judge's decision-making in sentencing. And this is the window to talk about that idea of the Parliament has the final say on what the courts do. But then we get to see some examples of what the court does, which is looking in the eyes of those individuals and thinking about their particular circumstances when they apply the law. So that's an example of how OSLI works and how I would talk and think about the law rather than trying to do that deep case analysis.
I think you probably just inspired a bunch of the teachers to go and give it a try themselves to see what they can find. Now, I suspect that you'll probably get some follow-up queries. And if you like, Sarah, when I contact all of the teachers afterwards with their certificate, I'll make sure that they have access to your slides in this recording, but also your contact information at the uni in case any of them are interested in taking you up on your offer to showcase like the case citators and the other legal research tools that you've been mentioning throughout the session. So if you've got anything that you want me to share, I'll take it from you and I can circulate it to the rest of the group.
That sounds great. And, you know, I really can't bang on about OSLI enough. I just, you know, this is what happens with me. I start banging on. But another button on OSLI that's fantastic for students is this one. One of them is law reform. So many students are interested in, you know, technology in the law, or, you know, abortion or privacy or any of these topics that keeps coming up as social issues. Chucking that into the law reform button in OSLI gives them a report that's going to have the primary sources in there. It's going to have the paragraph that describes the facts of the case and does that IRAC for them. And I think that's a fantastic start. And the other button is journals and scholarship. So this is where you know what you're getting is written by an academic with a peer review. And so when I go to high schools myself, I'm just saying, instead of Google, just come to Ostly, because you'll get a source that becomes a map for other things you want to find. So yeah, I think it's a great one. But yeah, please reach out. I'd love to, do a deeper dive into anything that we cover today, and also learn from you. And if you've got things that you're using all the time that I haven't mentioned, please share them with me.
Okay, well, you've had a lot of wonderful praise come through, and I've just seen someone that says that the reference to Ostly will be invaluable. So I think you've just in your last few minutes managed to provide a huge amount of assistance to a teacher out there, which is great. I'm conscious of your time, Sarah, and also making sure that everyone's managing to pick up kids, make dinner and get their evenings underway. So I'll make sure that I pass on any extra information you'd like to share, Sarah, so the whole crew has it. And otherwise, I will wrap it up and end the session for all of us. I hope you all have a fantastic week. We're going to be back next Wednesday afternoon on the referendum process and how section 128 of the Constitution works and what a double majority means. And then Cornelia Koch from the University of Adelaide will be speaking about the voice specifically. I'm politically neutral, so I won't talk about the voice. I'll talk you through the process, and then we've got an academic coming to talk you through the politics and the concept. So thank you so much again, Sarah. I hope everybody has a lovely evening and a lovely week, and we will hopefully see you soon. Thank you.
Thanks, guys. And anything you're looking for as well, if you're just saying, oh, I really need a source on whatever, just shoot me an email and I'll find it and shoot something back. Yeah. Okay. Thanks so much. Thanks, Nat.
Good evening. See you later, everybody.
Bye.